All right, everyone, listen up. The Minnesota Debt Fairness Act goes into effect October 1st, 2024. In this video, I'm going to tell you what's going on, what it means for small healthcare providers. I'm going to go over three big things. One, what the rule actually means. Two, we're going to focus a lot on medical necessity and when a provider may not be able to deny care, even if a patient can't pay. And three, we're going to talk about the lesson learned here for the legislature and the unintended consequences of poorly written rules. So, without further ado, let's go. So first off, what's going on? The Medical Debt Fairness Act was passed this year in June of 2024 signed into law by Governor Walz, now running for VP. It's going to go into effect on October 1st, coming up quick. This is really a law that's been designed to work with medical debt. But when I'm looking at it from the perspective of a small healthcare provider, it means a lot more. Because the biggest questions that I'm getting right now from small healthcare providers is, can I deny care to a patient who hasn't paid their bills? Period. Very high level, seems like a basic, tenet of business. Maybe not so much when you're in a hospital setting or you're in a setting where, you're billing insurance, emergency care. That makes more sense. But let's just say, to really dig into the first point of medical necessity, what does that actually mean? So I'm going to read from the law what we have medical necessity as. It is healthcare services or supplies needed to diagnose or treat an illness, injury, condition, disease, or its symptoms, and that meet accepted standards of medicine. Seems pretty broad and vague. Treatments like blood tests, follow-ups, etc. are all considered medically necessary as part of an accepted treatment of care. This will usually vary based on which kind of care each provider is giving. That's generally the accepted rule. So not a whole lot of guidance in the law itself, as well as the government's interpretation of it, which is frustrating. So to be in compliance with the law right now, the biggest thing that providers need to do is they need to publish some sort of medical debt collection policy and practice. And I have a sample one that I'm going to send out. Link to this video. It's going to be on the website. You can simply use that as your own. I think your biggest job will be to figure out what is medically necessary in your practice. So the law does not give much guidance. It doesn't say, oh, well, if it's this type of blood test, you're good to go. But if it's therapy, and it's this type of therapy, don't worry about it. This puts a small healthcare provider in Minnesota in a really difficult situation because you may have individuals who switched insurance isn't going through, now you have patient responsibility. The patient has racked up $1,000 tab for therapy. They're coming in and they just had a pretty, big life situation, big life event. Can you stop care in order for that patient to pay their medical bills? There's not a dispute over whether that debt exists. That is not what's going on here. It's more so, can the patient continue to, rack up the tab before the provider says, hey, no, you need to stop? That is the biggest question. I want to highlight a few other things that the law did. Other things that it did was ban medical debt from being reported to credit bureaus. Makes sense. Ban medical providers from withholding medically necessary care to unpaid debts. Eliminate automatically transferring medical debt to a patient's spouse. Fun fact, debt may or may not transfer to your spouse, depending on the situation in Minnesota. Or establish new medical debt collection rights enforced by the Attorney General and private right of action, including an attorney fee shifting and a per violation statutory damage award pegged to the consumer price index. This is what concerns me the most because I have deep respect for my colleagues in the defending those, or at least making sure that debt is collected fairly. I have deep respect for those attorneys. There are certainly some nasty debt collection agencies out there. But here's my concern for you, if any of the attorneys are actually watching this, is you have a small healthcare provider, a small business owner, usually a younger parent starting out as an entrepreneur, and they are the therapist who has a patient who's racked up $1,000. Are you going to use this statute as a sword to go rack up attorney's fees over this $1,000 that the patient owes the medical provider, and the therapist said, hey, no, I am not going to provide care. I need you to pay up before we can move on. That doesn't say that the therapist does not respect or care about the patient. It's actually the opposite. It's the patient actually cares about the professional services that are being rendered, so much so that they actually pay what they said they were going to pay. Hence why it's a debt in the first place. There's not a dispute over whether the amount is a debt. There's simply rules of engagement for how that debt is collected, one of them being, can you stop care? So let's just talk about some of the things that you cannot do in terms of medical debt collection according to the statute. So parties collecting medical debt cannot use robo-dialers to collect debt. Parties collecting medical debt cannot say medical services will be withheld if the debt is not paid. Very similar to what we were talking about before. Parties collecting medical debt cannot contact third parties about the debt. Hey friend, hey neighbor. Parties collecting medical debt must notify patients of their right to hire an attorney or contact the Attorney General regarding the debt. That was largely already a rule regardless. Parties collecting medical debt cannot violate the Fair Debt Collection Practices Act or any other Minnesota law. Let's just clean up these last three, and then I'm going to talk about why I think this is poorly drafted legislation. This also means that attorneys' fees are covered. I'm glad the attorneys who do this are getting paid. We need to require medical providers to publish their medical debt collection practices. I have in and attached to this video and on my website a policy that you can utilize. The biggest question being, when does something turn into a medical debt, right? Is it just sitting there as an outstanding something that's submitted, an outstanding claim that's been submitted to insurance as in processing versus handed over or has become an official medical debt. Another thing that I think was poorly drafted in this legislation, or the Attorney General has done a terrible job with their education for small businesses or small healthcare providers. Lastly, the law established a new process for patients to dispute incorrect coding or billing of medical care. So that's somewhat related, largely a technicality, probably could have done it even without the law. So here's my frustration with how the law was drafted. So makes sense for hospitals, nasty, ugly medical debt collectors, those bunches. We'll just kind of put them off in another category. But what about small healthcare providers? Again, the therapists. The patient racks up a tab, $1,000, and now we need to deal with how can that therapist say, I will no longer provide care? Is that care medically necessary? Is there a medical debt? Are they in violation of this statute? So now an attorney can come out of the woodwork and sue them, get all their attorney's fees. Plus, I don't think it absolves the patient of actually having to pay the debt. But now that they're in violation because they asked for the debt to be paid, you have a small healthcare provider who I think was just trying to get paid for what they did being punished. So this is what I think sometimes happens with legislation, and where I'm going to close out this rant of a video is I think the legislators meant well. They were trying to protect patients against situations where they could not pay and were in an emergency situation or needed care to the extent where it was life-threatening. That would have been probably a better use of words here. But the unintended consequence now is that small healthcare providers who are providing great care, but medically necessary, I mean, isn't everything medically necessary with how vague this rule has been written? Smaller healthcare providers are caught in between a rock and a hard place where they don't want to violate this rule, but at the same time, they want to get paid and not go into debt and potentially go out of business, which just makes more patients go to big healthcare, which ultimately doesn't really benefit anyone. So I think how this rule was written at the Minnesota State Legislature could have been done better. I'll just leave it at that. That's what's going on with the Minnesota Debt Fairness Act. Follow, like, share if you found this video helpful, and certainly at the bottom of the video, look for the sample policy that you can use as a small healthcare provider. Thanks.